afternoon, everyone. Thank you so much for joining us this afternoon. Here at the Chamber, we continue to connect you to businesses, information, and each other, now virtually and in person. And today's program is no exception. So thank you to Porzio, Bromberg, and Newman for their support and for presenting this very topical and much needed talk today. So with that, let me introduce our panelists. First up, David Carlson. David is a principal at Porzio in the business law team, and he counsels clients on a range of transactional matters, including commercial agreements, strategic alliances, mergers and acquisitions, corporate governance issues, new entity formation, and day-to-day business questions. Relying on his experience in both private practice and in-house as general counsel, David has broad experience in different subject matter across areas of multiple industries, including the cannabis, real estate, technology, hospitality, and pharmaceutical industries. Prior to joining Porzio, David served as the general counsel of a hospitality startup, general counsel of a business unit of a Fortune 500 hospitality company, and associate general counsel of a pharmaceutical company. In each of these roles, David has worked to build relationships with his colleagues to better understand their businesses and to help formulate solutions to a variety of issues. More than anything, David views his most important role as helping clients to solve problems. Next up is Kerri Wright. Kerri is a principal and co-chair on the employment law team. She focuses her practice in the areas of employment and education law, specifically in representation of management in both employment counseling and employment litigation. Kerri handles a variety of employment law matters for the firm's public and private sector clients in state and federal courts, as well as before administrative agencies, including the EEOC, PERC, NLRB, and the New Jersey Department of Labor. She has litigation and counseling experience in numerous areas of employment law, including issues resolving wage and hour claims, restrictive covenants, harassment, discrimination, and whistleblowing. She successfully has defended management in class action wage and hour lawsuits and has handled numerous investigations by management into allegations of employee wrongdoing. She also has represented management in all facets of collective bargaining and labor disputes, Okay, Beau Huch is up next. Beau is of counsel at Porzio and a member of the litigation practice group, where he counsels clients on compliance and regulatory issues relating to the emerging cannabis market. Beau also serves as director with the firm's lobbying subsidiary, Porzio Governmental Affairs. He advises clients on strategies to navigate the legislative landscape in the areas of cannabis, healthcare, environmental, and law enforcement. He previously served as a legislative aide to New Jersey's 10th Legislative District Office, and most recently served as the legislative director to New Jersey's 13th Legislative District State Senator Declan O'Scanlan. Beau collaborated with governmental agencies at the state, county, and municipal levels on critical matters of public and private enterprise concern. Additionally, Beau has dealt with highly polarizing and sensitive topics such as vaccines, social justice, and a plethora of issues that impact the state budget. He was instrumental in expanding the New Jersey medical marijuana program and creating a pilot program to research the cultivation of industrial hemp. So very topical for today. And last but not least, we have Ivan Tukhtin. Ivan is a member of the business law group. He concentrates his practice on assisting middle market businesses with matters related to commercial and business litigation, labor and employment, as well as cannabis law. Ivan has counseled clients on numerous matters, including, but not limited to, business formation, contract disputes and negotiation, mergers and acquisitions, the drafting of employment agreements and handbooks, and trademarking. And with that, I will pass it over to our panel. So David, do you want to take it away?
Thanks, Kelly. It's great to be here with everyone. Rather than going through a PowerPoint, I thought we'd do a little Q&A. And starting with some of the basic terminology, because we hear cannabis and CBD and THC and other terms from time to time, or start with kind of level setting, seeing what they mean and how they work together. And so, Ivan, help us understand what is cannabis, what is CBD, what is THC, how do they work together?
Good afternoon, everyone. Thank you for joining us. Cannabis is generally referred to the genus of plant. So starting all the way at the top, and then from there, we'll break it down. You can either have what everyone refers to as marijuana, which is the psychoactive variant of the plant, which contains THC, the psychoactive ingredient, or you can have hemp derived from the cannabis plant, which is primarily containing CBD. Hemp, just so everyone knows, to be qualified as hemp, you have to have 0.3% THC or less, meaning you do not have the psychoactive ingredient in there that marijuana does on the recreational side. Additionally, you can have what is referred to as isolates. So an isolate is a type of product that takes the purest form and isolates it. So generally marijuana contains both THC and CBD. So a marijuana isolate, for example, would contain only THC, the purest form. So Beau can touch a little bit on what isolates have kind of become today to give you a better understanding of that.
Well, first off, thanks for having us. I'm going to rely heavily on my colleague Kerri right now to wiggle her ear if I get too in the weeds on this, just because this is a subject near and dear to a lot of our hearts right now as the industry has its rollout. And when we think about cannabis, it's go to grade school for a minute, and this is why it gets so confusing for so many different people. This initially was a genus species situation, with cannabis being the overarching term for a plant, and hemp being one aspect of it and marijuana being another, which is something we all kind of grew up just having a general understanding of. And then down the line, we had a situation where lawyers got involved. And the lawyers got involved around 2018 with the federal farm bill that went through. And this is going to sound strange for just a minute. We envisioned with the federal farm bill, and this was Senator Mitch McConnell at the time, was trying to really push through the interstate commerce of hemp, because Kentucky's a big hemp producing state. And we derive a lot of CBD from hemp. And in a nutshell, with this big bill that went through, they talked about hemp-derived products. That's cool. Well, the vision was always that the Department of Agriculture would regulate hemp, and that the DEA would regulate that very evil, illegal substance, marijuana. And in time, the FDA would regulate this definition of cannabis, which is just marijuana made legal by states. Doesn't really go with the biology of it, but hey, we have a legal framework now. And at least on paper, you can tell when it automatically means the criminal code when it says marijuana still. Most states at least adopted that. But the problem is we talk about hemp-derived products, and the FDA has really not come out with any rules or regulations yet for the consumable of CBD. And in the process of this extraction from hemp to get that CBD that you can get that from. You can get it from cannabis, marijuana as well. But in that industrial process, you can also get a different type of isolate, such as something like Delta 8, which is about as 50% as psychoactive as the typical psychoactive substance, Delta 9, that gets people high. And this is a little alarming because it's completely unregulated right now, and you've seen it enter into the stream of commerce. So the feds are kind of at a standstill right now, and the FDA is saying the quiet part out loud of, hey, this isolate of Delta 8 can now legally cross state lines. There's nothing we can really do about this yet. So states are proactively trying to deal with this. There's other types of isolates out there. They're usually the most purest, strongest form. This is something that can trip a drug test up. So just be cognizant of that.
So, but let me just follow up on one thing you said. You said that Delta 8 is kind of in commerce. And what form is that in commerce? When you say, where would you see it typically?
And this is what gets so scary right now. It's, you think of cannabis, you think of marijuana so often as a flower, but you can refine this flower down to an oil, a tincture, whatever it may be. With these isolates like Delta 8, you can see that end up into gummies, into chocolates, whatever it may be, just like anything else in the cannabis space. Except the big difference is it's kind of a gray area right now as to its ability to cross state lines. Federal regulators have said, hey, don't do that. And that's what spurred a lawsuit in 2018. And basically the Department of Agriculture lost out. Well, actually, the Department of Agriculture won because this is a hemp-derived product. So we're really in a very, very strange place right now legally. Again, some states have proactively begun to ban it.
But to add to Beau's point, there, Delta 8 is one of the things that's derived from hemp. So in some states, you'll even see it for sale in random grocery stores or CBD products in grocery stores. So the key terms, THC and CBD, they can coexist in a product. So when you see something labeled full spectrum CBD, that probably contains traces of THC because it's not an isolate. In fact, there's a company in California called Curaleaf that's recently just been hit with, I believe, about 14 lawsuits for CBD products that had high traces of THC, which not only triggered people's drug tests, because most panels test for THC and not CBD, and also gave them a hallucinogenic effect. And some people had really bad psychosis that checked them into the hospital. So CBD products are, as Beau said, a gray area that's unregulated. And unless you know for a fact you're getting something that's in the purest form of CBD, you could still end up taking THC without even knowing it.
All right, we'll get to drug tests in a second, but I hear people all the time saying, well, cannabis is legal in New Jersey. So what does that actually mean right now? What's allowed under New Jersey law, and what, if anything, or how does that work with federal law, I guess?
Sure, I'll touch upon it briefly. So New Jersey's actually had a medicinal program for the better part of a decade. Granted, it wasn't expanded and improved to be something very valuable to the state until recently by the Jake Honings Act. But recently, New Jersey did legalize marijuana, and it's legal to possess, but you can't legally buy it yet. So you have to be 21 years of age or older to possess it. You can possess up to 6 ounces, which is a lot to possess at one time. There is no home grow, so you're not allowed to just plant it in your garden, contrary to what people think. And you generally will no longer face serious consequences, but there are still the sort of person's offenses and charges that you could potentially face if you're smoking in public, stuff like that. So it's generally decriminalized, but you can't go and buy it anywhere. And with that, I'll turn it over to Beau.
We have been on a very long odyssey here in New Jersey as this has evolved since 2010 with the first passage of CUMA. And CUMA was the very anemic, simplistic, you basically had to be on death's door medical marijuana program. 2019, we really expanded it with Honig's Law. And then from there, we really expanded it again. Not expanded, we created a legal framework with CREMA in this 2020. And I just kind of want to just throw this out there too. When we talk about the evolution of the industry and where we exactly are right now, we envisioned, and I worked pretty extensively on Jake Honig's Law, we envisioned an up and running Cannabis Regulatory Commission within like 6 months. We obviously got hit with a pandemic within that period of time, and things slowed down a little bit. And the Department of Health used to administer the medical marijuana program. So obviously they've been really busy, and the people that really used to, you know, all the manpower, the surge capacity, they've been preoccupied. So when the CRC finally got up and running and seated, a lot of the people they needed for expertise were slowly being tried to be pulled in. Civil Service Commission hires take a long time. So they've missed a few deadlines as the industry has kind of rolled out. Regulations have taken a little bit longer. You got to give them a little bit of credit here because they're operating under incredible, extraordinary circumstances. And as far as the law is concerned, February 15th is supposed to be the first adult use sales. We just had this past December another round of applications for manufacturing and cultivation licenses. It's going to take a long time to score them. This March, we'll start accepting new license applications for retailers. It's going to take, again, a long time to score them. I anticipate a good amount of time to score them. So what I'm getting at is, if February 15th is supposed to be the first adult use retail sales, and they have some real bandwidth issues right now, I'd expect the CRC to be moving a little bit slow as far as that rollout. I wouldn't be stunned if they blew past that deadline either. Could happen, you never know. They have surprised me in the past, but that's where we think things are at right now.
So Beau, just to level set for everybody for a moment. So if I see a dispensary in my town, I should think of that. That's for medical marijuana only today, right?
Yeah. So if you have somebody that, and this is where it gets very kind of odd for a second too to think about. it's relatively easy to get into the medical marijuana program right now. We tried to make this a very liberal program to provide patient access for so many individuals. It's not a high bar to get into like it used to be. So the dispensaries that are operating right now, they're vertically integrated. They tend to be bigger operations. And if you have an employee that might have come up positive for a drug test, you have to be careful. We'll get into that in a second as to how you address that situation. But there's a good possibility that they're in medical marijuana program. It's become a very mainstream situation. So there are people that do imbibe in the black market to a degree. It's not impossible to get cannabis that way. You're not supposed to. No one's supposed to be selling it outside that existing medical marijuana program yet. But February 15th, we will find out more if that actually is allowed to happen and the public's allowed to start purchasing without a medical marijuana card.
Okay, so if I'm not registered today, I can't buy it for medical marijuana purposes, but then once the retail licenses start getting approved by the state, then you'll see retail shops selling it to people who are 21 and over, regardless of your medical circumstances. Is that right?
Yes, but the existing medical marijuana operators, if they certify to the state that they have sufficient supply to service their existing patients, they may too sell to the public. So those existing operators on February 15th,
Got it.
in theory, could start selling to the public. As far as the new retail, we refer to the medical program, those are dispensaries. As far as the adult use program, we refer to those stores as retail operators.
Got it. All right, that's helpful.
One's been approved for retail operation yet.
Yep, got it. Okay, that's great. So let's shift over to the employment side a little bit, get Kerri involved. We've talked about drug testing. I'm an employer. Can I do a pre-employment drug screen, Kerri?
So the answer still is yes. But then there's all the caveats, right? We wouldn't be four lawyers having this discussion if there weren't a number of caveats related to that. So yes, and I think Ivan's got this specific language for us on the Jake Honig Act, which provides employers with a good amount of guidance on what you're permitted to do. But the general overall answer to your question, Dave, is yes, you can.
To piggyback on what Kerri said, I'm going to read the specific law of the medical program. So going forward, employers and businesses need to remember that there is a very big distinction between a medical patient and a retail cannabis user. So a lot of this is going to hinge on whether you have a workplace policy, which Kerri will get into detail. So the medicinal law specifically says, if an employer has a drug testing policy and an employee or job applicant tests positive for cannabis, the employer shall offer the employee or job applicant an opportunity to present a legitimate medical explanation for the positive test result and shall provide written notice of the right to explain to the employee or job applicant. And Kerri, what are those implications in the real world?
So in the real world, that basically means that you can't have a hard and fast, if you fail a drug test pre-screening, you can terminate or not hire an employee. So the practical implications is you need to have a conversation with the individual. For all of our employers out there, you're probably having these conversations with folks along the way under the Americans with Disabilities Act, the New Jersey Law Against Discrimination. When anyone presents to you a medical issue, whether they need a leave of absence, whether they need a different chair, whether they need some accommodation, you're engaging in an interactive process with them. I look at this from a practical standpoint as very similar to that, and that you're going to be engaging in this interactive process with them. You can't just simply say, oh, they failed it, put them in this pile over here and not have further conversations. You've got to follow up with them.
Right, and one last thing to add to that is there's a carve out in the law that also allows the employer to have still a drug and alcohol-free workplace policy. So it says, nothing in the section shall be deemed to restrict an employer's ability to prohibit or take adverse employment action for possession or use of intoxicating substances during work hours or on the premises outside of work hours. So you don't have to accommodate the use on the workplace.
Right.
Yeah,
well,
that is a very good point, and a lot of employers want to know that. Now that it's legal, is it something that I have to accommodate? And no, it's very similar to alcohol, right? It's certainly legal for your employees to go out on a Friday night and have a drink, or a Saturday, or when they're not at work, but you don't have to allow them to bring it into the workplace and consume it while they're working. Sorry, Beau, I know you look upset about that, but
No, it's just this whole situation where we are as a state right now, where we are as a country, it always blows my mind, just because here we have a substance that is still federally legal. It's still a Schedule 1 as far as the feds are concerned in the Controlled Substances Act. But meanwhile, at the state level, we've granted certain employee protections for cannabis users, for medical marijuana patients, and we have to be very careful about onboarding new employees as to the questions we ask them, the how we ask them. And this is all coinciding at a time. Think about everything else we've talked about right now with these isolates and the CBD being able to cross state lines legally, although there's no regulations in place for really how to consume these things. But there's never been more time and opportunity for a person to trip up a drug test and have those metabolites detected on a drug test than ever before than right now. So a drug and alcohol work-free policy gives you a lot of different protections.
Oh, and we just talked about the medicinal program. So now let's flip to the recreational side. So recently the CREMA regulations have been enacted, and it specifically has certain employee and employer protections there. So the law specifically says no employer shall take any adverse action against any employee because that person does or does not smoke, vape, aerosolize, or otherwise use cannabis items, and an employee shall not be subject to any adverse action by an employer solely due to the presence of cannabinoid metabolites in the employee's bodily fluid. So, Kerri, what does that mean for people that want to smoke on the weekends?
So that means that they can smoke on the weekends. You can keep them from smoking during the weekday when they're actually working for you. But you can't take action against them solely for that. So what does that mean? So that means that if someone is smoking, whether it's at night or vaping at night, and they come into work, if they engage in something that's a violation of your policies, a safety violation, something along those lines, and you certainly can discipline them. The only limitation you have is you can't discipline them solely because they have tested positive, because there's some, and Beau can talk a little bit more about this if you want to jump in with the how long those metabolites stay in your system. So it's a little bit different than when you're testing for other drugs and even for alcohol. So the issue though is, look, you can still enforce your policies. You can still discipline employees for their infractions. You just need to make sure that you're disciplining them for the infractions or the policies, not solely because they use cannabis now.
So without getting too much in the weeds on this when it comes to how long it stays in your system and whether or not the method, I should say, in which you test an individual. I mean, how long cannabinoid metabolites stays in your system depends on so many different factors: your body mass, your metabolism as a whole, how frequently you imbibe. A person that smokes once every 6 months or consumes every 6 months might only be in their body for a couple of days before you burn it off, several days. You do it pretty regularly, it can be in your system for well over 30, 45 days. So when you're talking about a blood or urine test, that can pick up metabolites for long after you've ingested it, which makes this such a really tricky situation because the technology for impairment has really not caught up yet. There's been a lot of discussion about, well, maybe we could do a saliva test or a breathalyzer test. There's even just recently been a big study published on a brain scan for impairment, which shows a lot of promise. But the complexity of cannabis and the range of potency it's so difficult to have an evaluation for impairment. So what the state built into law and what we really envisioned going forward was to build upon what's known as a drug recognition expert, which, a drug recognition expert is a highly trained police officer that knows how to do a physical evaluation of an individual to help determine what substance they may have consumed based off of the state that they find them in. Now, obviously, every business will not be hiring a drug recognition expert to come in and be checking out somebody. We kind of envision what next could be maybe a little bit of a lesser standard that just has like the real bare bones for cannabis, which is something we would call a workplace impairment recognition expert. Now, workplace impairment recognition expert, think of somebody in your office that might be trained to deal with an AED. They're not an EMT, but they do have some basic training here to determine the basics for that exact situation. It's a pretty analogous, comparison when I say this was intended to figure out, hey, we could have a workplace impairment recognition expert to determine on-the-job incidents or random drug screening, whatever it may be, of a person that we suspect using it. Now, there's a bit of a catch with workplace impairment recognition experts. We could go down that rabbit hole now, or Dave, did you have anything?
Well, I was just going to ask you, if I'm, I own a business, I have, say, 50 people, I've got an HR director. Should I be hiring someone right now to learn how to do this? Can I do that?
No.
No. Okay. Tell us why.
This always gets a little fun, and Ivan and I have beat our heads against the wall a few times on this. We all just kind of hear at Porzio, we're waiting anxiously for something to happen.
So before you get into that, let me read what the law says, and then you can say why it makes no sense. So as Beau said, the law has a requirement for employers to have a workplace impairment recognition expert to do, tests if you think someone is impaired so that you can drug test the employees. So the law says, until such a time that the commission or the Police Training Commission establishes and develops standards for a workplace impairment recognition expert, no physical evaluation of an employee being drug tested shall be required. So Beau, where does that leave us?
So we've had a few different situations going on in the past couple of years. There's that pandemic I talked to you about. There's Trenton and all the politicians with their legislative priorities, because the other hat I wear is, aside from Porzio Bromberg Newman, I'm with Porzio Governmental Affairs, and we're actively on the ground here trying to get insight as to what's always happening. And Trenton has had a high priority for police reform, and police reform would entail really overhauling the Police Training Commission. That would be a big deal if that were to happen. And that would take up a lot of bandwidth. In addition to that, back in 2019, right around the time of Jay Koenig's law was passed, there was a police stop. And this situation, this police stop evolved into a case called State of New Jersey versus Olenowski. And with this situation, the plaintiff was questioning the validity of a drug recognition expert and the science behind it. Well, where things are at right now is there was a special master assigned to this of the state Supreme Court to do an evaluation. They heard oral arguments on this situation in November. That case is finally starting to wrap up right around now. Think about it, happened in 2019, just had oral arguments on scientific experts in November, and we're still kind of working our way through it. The special master will be inviting everybody to involved in that case to do closing arguments. Then it's going to take a while to issue an opinion. And that's when they just square away the drug recognition experts, and the Police Training Commission will be able to deal with that. So with the workplace impairment recognition experts, until the DREs are really squared away, the CRC really can't begin to pin down what a workplace impairment recognition expert is. So to answer your question, David, should you hire somebody right now who's a workplace impairment recognition expert? They don't exist. So if you're a business that's out there right now that's trying to protect yourself, you have a few limited options, and the strongest one is a very good drug and alcohol free workplace policy.
The way that I look at it from the employment perspective, just to sort of sum up what you said about Olenowski, is that right now the courts are fighting over whether police officers really have the ability to be a drug recognition expert. And so we're talking for you as far as employers, a step down from that, you're talking about the workplace recognition person that you're going to be hiring. What Beau said was the wire, right? That's the acronym for that. So if the courts haven't decided yet what a police officer's qualifications can be, should be, that needs to be decided first. And then we can start training more or less civilians, I guess, for lack of a better word. All right, so until we figure out what the police need to be doing and what they need to know, you're not going to get your workplace civilian expert, so to speak, on this topic. And so the law, as Ivan, you just read, basically says until all of that happens, you as an employer can't hire someone who's going to be deciding whether somebody is intoxicated or impaired by use of cannabis. So you're sort of stuck between a rock and a hard place. So our advice and recommendations are really be focusing less on whether someone appears to be impaired and trying to make a determination if they're impaired by virtue of cannabis use, but what are they doing? Obviously, if they are acting in a way that makes you suspicious as an employer, as a boss or a supervisor, they're doing something. So I still think it's perfectly lawful for, as an employer, for you to say, okay, well, this person was weaving as they walk down the hallway, slurring their speech, talking really, really fast and not really making a lot of sense. They made this mistake or they were combative. So you're wanting to be documenting what they're actually doing as opposed to trying to make an assessment as to whether you think they are impaired.
So don't go to the conclusion, just talk about the different steps. I mean, so let's stay on that for a moment, Kerri. You know, it sounds like having a policy, an alcohol and drug policy, is very important for the workplace. And, you know, getting the policy right will hopefully avoid a lot of these issues. But let me ask a practical question. If, you know, I'm an employer, I like to have, occasionally I have a celebration if the company does well. We serve, you know, beer and wine after work on a Friday to celebrate like getting a client or something like that. Can I allow that, but still say no gummies, no cannabis? I'm just going to not let you do that, but I will let you have a drink after work at a company function.
Sure, but I'm going to say it goes back to depends on your policy. So okay. Let's make sure that you pay a really very close attention to putting together a policy that provides for what you're willing to permit your employees to do while they are on your property. Or even, you know, as you've said, Dave, a lot of times there are off-work premises get-togethers, but they are sponsored by the company, right? They are put together by the company, maybe they're paid by the company. So your policy needs to address what your expectations are while they are, quote unquote, on the clock, but also while they are at social gatherings that are related to or sponsored by the company, what your expectations are for their behavior. And I don't see anything in the law that says that you as an employer can't say, look, alcohol is fine while we are at a work related event, but cannabis is not okay. I don't think from an employment perspective, there's any reason you can't put that in your policy.
Okay. So once again, just the policy can say you can't use alcohol or cannabis during the workday, period, full stop. But, you know, you can say at a work sponsored event, alcohol is, if served, is allowed, but cannabis is not, or you can allow it. It just depends how the policy is written, right?
Mm-hmm. Yeah, I don't see any reason why you couldn't. Same way where you could, as an employer, if you wanted to say, look at company-sponsored social events, alcohol is okay, but hard alcohol is not. So only, beer or wine.
Right.
Because we don't want people getting completely, obliterated. So I think it's perfectly acceptable, and I don't see anything in the law that would prohibit, and as an employer, you do that. You just want to be consistent with your policies.
Got it. Can I go back for a second just to we start with drug testing, but the application process. So someone fills out an application for a role in my company, and she acknowledges she got arrested for a cannabis offense 5 years ago. Do I have to hire her?
So are we talking about the application itself?
Yes.
Yeah. Okay. So
Yeah,
on
sorry.
the application, we're going to have like a hard stop there with certain questions. You want to make sure your application or even your advertisements for your employment, you want to be careful. So New Jersey has something known as ban the box. So you've got to be careful about putting a box on your advertisements or your job applications that ask for arrests or criminal convictions first and foremost. So you want to be careful there because you're not supposed to ask until the first interview. The purpose really behind that is that the legislature decided that they really wanted folks to have a chance. They didn't want those that had been convicted of a criminal offense to be completely taken out of the running for jobs just based on paper until you get a chance to maybe explain in person during an interview, make a good first impression during an interview. So the answer to your question is definitely don't do that.
Okay, good. That's helpful. Thank you.
Hey,
Go ahead, Beau. Sorry.
just mind if I ask Kerri a quick question? Just, hey, Kerri, refresh my memory. If you have somebody that got through a pre-employment screening, they didn't, this didn't come up on the application. There was obviously no question about criminality asked. What happens if the position is a safety sensitive position? What happens if the position or the employer is subject to certain federal contracting requirements? And in the pre-employment drug screening, they test positive. What are the employer's responsibilities in that scenario?
So employers have a little bit more flexibility there. And I think for a 40-minute seminar for us today, I can't get into all of the complexities, but because it is still unlawful under federal law, you may have some federal contracts, DOT contracts, that require you to have certain policies in place, including a completely drug-free workplace. So generally speaking, you can still enforce those under certain circumstances. So I would say for anybody listening, if you do have certain safety sensitive positions, if you are a signatory to a federal contract, if you've got DOT contracts, things like those, you're definitely going to want to speak with legal counsel to specifically decide what you are and are not permitted to do, as these two areas of law intersect and at some points collide with one another.
Okay, that's
so
helpful.
That's a great question, Beau.
Yeah. So before we move over to Q&A, I wanted to touch on a couple of more general commercial type issues. And, there may be some members of the audience who own commercial property and have been approached by someone who's starting up a cannabis retail business and wants to lease space at that commercial property. Anyone have any thoughts on what you as a landlord, commercial landlord should think about leasing to is it okay to lease to a cannabis business?
Yeah, absolutely. The first step is always have a robust lease. And the second part is you really need to understand what they're going to be using the premises for, whether it's going to be cultivation or retail or, any of the other classes of licenses, because they all require different ventilation requirements, different security requirements. So it's not just like a one lease fit all kind of system. And then there's additional requirements for common areas if you're in a strip mall, if you're like one of those speedy marts that has another location inside of a building, and Beau, you can touch upon the strip mall issues.
Strip mall conundrum always kind of drove me nuts with the initial statute and regulations. And, where we're kind of at with things right now too is, there's a bit of an evolution here as to how the CRC has interpreted certain things. So my big question that always drove me nuts is, in the statute, it always said there's certain setbacks to food establishments. And then, the way statutes work is you have definitions in the statute. And if you're missing definitions or defined terms, you can clean it up in regulation. And even with all that said and done, there was still a bit of confusion. My simple question is, and this goes back to college days, could you have a cannabis retailer next to a pizzeria and a strip mall? And these two things would appear to go hand in hand. And a lot of people in this industry thought think that it would be no problem. Other states have had hard setbacks. Well, I was a little bit cautious on this based off the reading of the statute and the regulations. And we had a nice dialogue with the CRC. They were able to make clear that, yes, you can have these two things close to one another. Now, where it gets a little tricky, though, is let's say you shared a common wall between these two entities, and there was an open door that you could go back and forth between them. That's a no-no. If there's a service quarter back between the two, that's a no-no. So beyond that, too, you have to also think about when somebody is trying to lease your space, what's also happening at the local level. The state of New Jersey is a very, very strong home rule state. We give a lot of latitude in the law to what a municipality may restrict for these businesses. So there's setbacks to other things. You want to make sure that a tenant that's going in there for the longevity of the tenant and also the legality of the tenant, they actually are away from potentially a school or a church or a daycare, whatever it may be, because they do have some of those setbacks built in at the local level. And there are certain setbacks built in statute. So these are all different things to be aware of. The other thing I'll say that was a really interesting nuance I came across once. So, some landlords don't want smoking on premises. You don't want maybe somebody smoking a cigar in the building. That's okay typically to write into your lease. Now, if you were doing like a residential, being a residential landlord, for example, you can say that somebody can't smoke cannabis or aerosolize cannabis in the house, but you can't stop them from taking consumables. It gets really weird really fast, and there's a lot of different nuances to all of this. So it's, again, just a good idea to make sure that if you're leasing your place out, have a discussion with the attorney, have them do the review of the law, have them do the review of the regs, but also, most importantly, the type of building, the type of license going in there, and the local ordinance.
One last thing to add is just because they're coming to you to sign a lease does not mean that they have a license. Some of these people need site control or control over the building where they will have their business in order to succeed in an application, and they might file and not get it. So you may want to have a clause in there that says, we'll hold the building, but if you don't get the license, we're free to release. That way you're not tied and you have to, go into some kind of debate about who owes someone what. So that's the last carve out there.
And I just want to follow up on one thing Ivan said, just, because we've largely been talking about retail, leasing or retail space, but, you used the term cultivator, Ivan, and maybe just explain to the audience, does that mean, frankly, someone who's growing cannabis in the property?
So there are numerous different classes of licenses, but one of them could be a micro license. So which it means you have a 2,500 square foot facility and less than 10 employees. So you can technically do an indoor operation to grow marijuana on a small footprint. But with that, obviously, you're going to have some serious scent control issues, ventilation issues, which requires a lot of infrastructure and build out, which on a retail space is completely different. You don't need half of those requirements. So again, it's, as Beau said, very fact specific. Make sure you understand what exactly their business is going for.
And the last thing I just want to add too, and this is a recent situation that's been driving me nuts. When you all started your businesses, the first thing you probably had to deal with was the real estate issue. And similarly in cannabis, it's a lot like any other business with a few odd caveats. But real estate's the first most important step for a lot of these entities. And just like them, just like you you at one point probably had to look at a zoning map to make sure that your property that you were going to operate in is an acceptable property. Now, going back to all those setbacks and everything else that we discussed that may be in the local ordinance, that some of it's built into statute and reg, a lot of times the towns get very specific trying to drive these properties to very unique locations in the town. So double check with your zoning officer that your location, if you're going to lease out, is even an acceptable location, whether it's permissible.
Great point, Beau. Thank you. I was gonna, if that's all right with everyone, I was gonna move to Q&A. I see at least one question here, and we're gonna shift back to the employer side of things. So the question is, can an employer use audio and video to protect themselves if they are suspicious of drug use? Kerri, I'm gonna throw that over to you.
So I think the short answer, generally speaking, is yes. So if you're talking about putting in surveillance cameras in your business, it certainly is lawful for you to do so. I'll say with the one caveat being, if you have a unionized workforce under either state or federal law for private, there's a state agency too that governs public sector unions. So if you are a unionized workforce, you may have to negotiate with the union over the placement of certain cameras under certain circumstances. So it's something to keep in mind. But generally speaking, you have the right as an employer to put cameras in. Certainly, your employees do not have an expectation of privacy in your general locations. So your office building or your store. If you do think they have an expectation of privacy in certain areas, you're going to need to put that in your policy too, to let them know that they don't have an expectation of privacy. So a lot of employees will think, look, if it's the break room, I should have some expectation of privacy here. I certainly don't encourage you to put them in the bathrooms. That's definitely not a place where you should put your cameras. But putting something in your policy that lets them know that they could be recorded and that they don't have an expectation of privacy is a good first step in that regard. And as far as the audio recording, New Jersey is what we call a single consent state. So if you're talking about conversations that you are recording, that's okay, so long as one of the two or more people in the conversation know that they're being recorded. But if you are putting an audio recording device in someone's office and then you're leaving, and you just leave it running in their office, that's not going to be permissible. So I think you generally want to be sort of say open and notorious about your recording. If you want to put in cameras, make sure that your employees know you're installing cameras. Generally speaking, make sure that they know they don't have an expectation of privacy. I wouldn't try to be like surreptitious about it, and certainly not like leaving your cell phone in their office and walking away is not a good idea.
I mean, that you just hit on one of the follow-up questions, Kerri, while you were talking, where someone's asking, can I use my phone spontaneously? So I think it comes down to, if I'm sitting in someone's office and I want to record it, I have to be there. If I understood you correctly, and actually hit record. I can't just leave the phone there. I have to be participating in the conversation. Is that fair?
Yes, that is exactly it. So you can turn as an employer, you should know that most likely your employees are doing that too. If you have a disciplinary conversation with them, right? You should always just assume you're being recorded. So you can pick up your phone, you can turn it on, and you can walk in to a meeting. And as long as you are in that meeting, it's okay. So that's what a single consent state means, meaning so you think about it with like wiretapping with the police, they have to get a warrant because they're not part of the conversation. Right. If you're part of the meeting or the conversation, you're permitted to record it and you don't have to let people know.
But it all comes, ultimately it comes back to, I think, a point you've made several times about it's policies. Policies are critical here, putting it in the policy so everyone's, coming in, they know when they start working, this is the kind of the rule here, and you should expect you can be videotaped, accordingly.
Yep, absolutely.
I don't see any other questions. I'll pause there for a minute to give any of our viewers a chance to throw some other questions out there. But okay, well, it does not look like we have any other questions. So, on behalf of my colleagues, I certainly want to thank everyone for spending an hour of your day with us. And, we've enjoyed making this presentation. We'd love to hear from you if you have further questions and help along the way. So thank you, everyone.
Okay, thank you so much, everyone. I learned a lot sitting through this, and it was phenomenally educational and interesting. So I do want to put it out there. We would like to continue this conversation on the cannabis industry in various aspects throughout the year. So please keep your eyes on the chamber calendar for upcoming events. And again, thank you to everyone from Porzio for their help with this panel. So with that, I hope you all have a great day.